class a new title. It's called Forms Plus. Forms Plus. And the reason I did is because we'll talk about forms, and then if we have time, once we get through some of the forms that we're going to go through, then uh, you guys can ask me any questions. And do you know what? I'm not like a lot of uh, instructors. If you have a question that when we're talking about something, and don't hesitate to interrupt me and say, Don, can I ask a question? Because I would rather that you get your question answered at that time, rather than waiting till the end, like me, and then forgetting what your question was. So that happens a lot. So do not hesitate. So like I say, we've got Jeff Larson on here today too. So
Good.
you've got the two powerhouses here today.
Yeah.
Whatever that means, right, Jeff? So, but we appreciate you being here today. So, um, I am going to jump right in, you guys,
Good.
and we are going to um, let me share my screen here, and you should be able to see my screen.
Oh, those are pictures you probably don't want to share with people.
Yeah,
I'm just, it's
let me, what?
CC&Rs is what we can see.
Oh, can you see the CC&Rs?
Well, I could, but now I can't because you have
Yeah,
them
well, I
first.
just took them off because they're over on my side screen, so I think I'm gonna put them over here, and we'll try this again. Okay, hang tight. Um, okay, now there we go. Now you can see CC&Rs, can't you?
Maybe it's still
Blank.
thinking about
There
it.
we
Now
go.
we can.
Now you can. Okay, perfect. Okay, so you guys, we're going to start with I think all of you know the name Beverly.
Yeah.
Beverly, we are very blessed, and I mean that. We are one of the only states that has our own compliance person. In other states, the district directors, which Jeff and I are, they do their own compliance with their agents, and so we have someone that focuses just on compliance. And trust me, you don't want Jeff and I to do it because we'll be a lot tougher than even Beverly is. So maybe. But talked to Beverly last night, and she gave me just a couple of things um, that she's having problems with. So everybody sees that um, right on the screen right now. You can see that this is a kind of a normal copy of restrictive covenants, CC&Rs, they're commonly called. Um, and and these are very important because there's a tab where you're supposed to upload these in each folder that you create. Um, the CC&Rs, the problem that Beverly is having is if there's no CC&Rs, people are just clicking on the exception and typing in no CC&Rs. And what we want to make sure that you have checked to see if there's CC&Rs, going to give you a tip. We either want your CC&Rs uploaded, okay? Either the CC&Rs should be uploaded, or send an email to your title company and say, would you please either send me the CC&Rs if there are any, or send me an email that there are no CC&Rs for this property. So if there are no CC&Rs, then we are requesting that you make a PDF of that email that states that from the title company that there are no CC&Rs for this property. Okay, so that's something that is important because it's pertinent information for your buyer to have in particular, and so to 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 satisfy that tab, you either need to have the CC&Rs themselves, or you need to have an email from the title company stating that there are no CC&Rs. Does anybody have any questions on that? That was one of the things that Beverly said. She is having, like, she hasn't had major problems on this for a while, and now maybe it's because business did pick up there for a little while, and now she's having problems again. And you know what? Sometimes when we don't do a transaction for 6 months or a year, we kind of forget. Um, kind of what the process is. So if you ever do, don't hesitate to reach out to Jeff or myself. We're always available to help you, and we love doing that. Okay, so CC&Rs, either upload the CC&Rs or or an email from the title company. Has anybody ever had any problems getting CC&Rs? Anybody ever had any problems? I'm going to tell you I have. Okay. So uh, sometimes it's difficult because the you call the HOA and they say, yeah, they're CC&Rs with the HOA documents and they're on the website. So there's a couple tips that I'm going to give you. Um, you can usually get CC&Rs because if there's a third party company that's handling a particular project or whatever, um, the seller probably has a login to get to their account to get to all of the documents that you probably need. However, if that doesn't work, or if it's not a third party company, if it's somebody that's just ignoring you, um, there is a document that I wanted to share with you. It's not used very often, but this is actually a document that was created and passed by our legislature. So this is a state law. This isn't just a guideline or because the Division of Real Estate went to our legislature and told them that, look, we're having problems getting documents from these HOAs or from individuals. And so this is a document that you can fill out. It's a request for documentation, and it actually tells them that if they don't comply, that it says if the association does not have an active website, then the association may charge no more than 10 cents per page plus $15 per hour, blah, 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 blah. Penalties for failure to provide documentation. Failure to provide seller or seller's realtor with the documentation may result in the association A, paying the reasonable cost to copy the documentation, B, paying a $25 per day penalty for each day of the seller's request for documentation is unfulfilled. Starting on day 6, they have 5 days to get them to you. And then C, paying the reasonable attorney's fees costs incurred by the seller in obtaining the inspection and documentation. So this is a document that is not used very often. We don't like to play hard nose with people. So the best way to do it is either try to work with the HOA, talk to your seller. If your seller has a login to get into the platform where they have all of their documents and everything, you can get them there. I actually have had sellers give me their login and I go in and extract those documents. And sometimes there is a charge for them. Okay. And you can see that it says that they can't charge any more than 10 cents per page plus $15 per hour for the association's labor costs to provide documentation. Well, they're not going to be able to charge you any hourly if you're going on their website and it's saying that it costs $35 to get the documents. All you need to do is call the HOA and tell them, or send them this form and tell them, I went on the seller's platform and it says $35 to get the documents. And according to this, the legislature says you cannot charge me more than 10 cents per page. Okay, so try to collect CC&Rs and HOA documents on the lowest level possible. And like I say, the best way to do that is to start out with your client and with the HOA. And 9.9 times out of 10, they're going to cooperate with you. Jeff, do you have anything to add to that?
I would just add the title will also help a lot of times. And so if you need it, you can ask title. Title will go and get those HOA documents or CC&Rs, especially CC&Rs that aren't associated with an HOA. Title will almost always have those on file and be able to get those.
Yeah. So you all know that CC&Rs aren't just on properties that have HOAs. In fact, the first home I bought, it was a $29,900 home. Okay, that was in the dark ages, but
1903, if I remember right.
yeah, exactly. Um, but we had CC&Rs for our little neighborhood because we decided that we wanted, rules. For instance, I remember one of the rules is because we had some guy that was a mechanic and he would go park his car in his driveway, tear his car apart, and it would look like junk in that cul-de-sac, for weeks at a time. So one of the things that we put into CC&Rs was that you cannot do auto mechanic work in your driveway for longer than 24 hours. And so there are CC&Rs just for in regular neighborhoods. And like Jeff says, usually those CC&Rs are available and the title company can help you with those. So that is another resource that you can go to. Thanks for reminding me about that, Jeff. Appreciate that. Okay. Anybody have any questions about CC&Rs? If you don't have CC&Rs, what are you going to provide? You're going to provide an email from title stating that there are no CC&Rs for this property. Okay. All right. Let's go to the next one. Next, kind of problem child. And it is one that we have just been enlightened in this past month on a new way that we're supposed to be doing this a little bit. Okay. You all know what lead-based paint is. Okay. Lead-based paint used to be, when it first came out, many years ago, it was a big deal. And we've kind of let it go a little bit because people think that lead-based paint is probably been painted over 20 times since the house was built, because this is for properties that were built prior to 1978. So prior to 1978 would mean if the property is built in 1977 or earlier, then you have to do a lead-based paint disclosure. I think you all are familiar with this form. There's two sections that you have to check mark, and the seller needs to fill this out first. So when you take a listing, your seller needs to fill this out, and the MLS, at least the WFR MLS, requires that you upload this document to the MLS. This is one of the required documents that has to be on the MLS, and I'll explain that in just a moment here. But the two areas that you have to worry about for your seller is Section 1, I or 2I. You either have known lead-based paint and or lead-based paint hazards are present, you have knowledge of that, or the seller has no knowledge of lead-based paint and or lead-based paint hazards on the property. Okay. So if they have no knowledge, then B is going to be easy. It's also going to be 2I, because then seller would have no reports regarding lead-based paint. Okay. So if they have knowledge, then they may have reports. So they might check mark I and I. If they have no knowledge, it would be 2I and 2I, because they would not have any reports either. So that part's pretty easy. And then, of course, the seller has to sign it and date it. If there's two sellers, you need both seller signatures. And then in Section 2, the seller's agent has to sign and date it. Okay. That needs to be done prior to putting your listing on the MLS, because this has to go on the MLS with your listing if it's utahrealestate.com. Okay. Then the thing that we've been a little bit lax on is that C. You can see I highlighted it. Seller has attached the EPA pamphlet, Protect Your Family from Lead in Your Home, to this document. So the EPA pamphlet is supposed to be attached to this document. So it's in my view, it's kind of part of this document. Okay. So what we're suggesting to you is and somebody told me that Utah Real Estate, I forgot to go in and check, that utahrealestate.com is now requiring that you also put the pamphlet as one of the documents. Do you know if that's true or not, Jeff?
I don't think that's true, but I'll check while you're talking.
Okay, yeah, because one of my agents told me that, yeah, I had to put the pamphlet on there, but I hadn't seen that yet. But anyway, one of the ways I went to a class that was taught by a very good broker, a friend of mine that I know, and that broker said that what they're doing for their offices, and we're at this point, we're making very strong suggestions to you, because it's that important, because the EPA is the one that is cracking down on whether you're delivering the pamphlet, Protect Your Family from Lead in Your Home, whether you're delivering that to your client, if you're the seller, delivering it to the buyer or not. Okay, so what that broker is doing is they're having the buyer actually sign page 2, either page 2 or the last page of the pamphlet, and dating it, showing the date that they received the pamphlet. I think that's a great idea, and that's what I started doing. So, and then because it says seller has attached the EPA pamphlet to this, I'm just uploading the EPA pamphlet that's been signed by the buyer with this form into the file that I've created for that particular property in IntelliAgent. So let me tell you why you want to do that. The EPA is cracking down on this, according to the Division of Real Estate as well. EPA is cracking down on this, and your first offense is an $11,000 fine. $11,000, you guys, $11,000 fine. So, um, that's a pretty hefty fine. I just muted everybody because I was getting some background noise. So if you have a question, you'll have to unmute yourself. So anyway, where can you get the EPA pamphlet? First of all, um, Jeff has been so kind as to we've always had the English version in the Fathom forms, which you know how to get to the Fathom forms. You go into IntelliAgent, go down to the Fathom tab, click on that. It gives you a drop down menu. Go down to the last choice in the drop down menu. It's resources. That opens up the Fathom forms. In the Fathom forms, we now have not just the EPA pamphlet in English, but the EPA pamphlet is also in Spanish. Okay. Jeff, you have something else to add to that?
No, I was just going to report back. The MLS is not requiring the pamphlet, just the disclosure document.
Okay, thank you. I didn't think they were. When an agent told me that, that sounded kind of strange because it's not the MLS's job to make sure that you do your job. Okay. So here's something that Jeff and I really want to impress upon you, and that is that this EPE pamphlet, it's not our job either to make sure that you deliver this. Okay, we're making strong suggestions to you, and I'm making a suggestion that go ahead and upload it into IntelliAgent, but we're not requiring it at this point. Go ahead and upload it along with the lead-based paint disclosure, just because it says that this is attached to it. So go ahead and upload it with this document, and then you have one place that you can go to if you ever need to access it. However, you are the one responsible to keep copies of all your documents on all of your transactions. So I don't know if you have a file that you create in your email for each one, or if you have files, in your document section or your downloads or whatever. You need to keep things for a minimum of 3 years. Okay.
3 full calendar years, which
3 full
usually means
calendar
4
years. So
years.
like if you do a transaction right now, we're into May. 2025 doesn't count. So you got to keep them for 2026, 2027, all the way to the end of 2028. Okay. So 3 full calendar years. Okay. So that's how important the pamphlet is. So, and then of course, what a lot of agents still don't understand the difference between this document and the lead-based paint addendum. Okay, so let me quickly explain that to you. Okay, so
Hey,
once
Don, before you do that, did you cover section 3 that's initials and not check marks? Sorry, I was
no, we're
looking at
we're
the
getting to that.
MLS.
We're getting to that here.
Oh, okay. All right.
Okay, yeah. So that that's what I want to explain how you use this document. So when you receive this from the seller, okay, um, uh, you're going to answer in section 3. Your buyer is okay. So it states that your buyer has received copies of all information listed above, including the pamphlet. Okay, buyer has received the pamphlet. Protect your family from lead in your home. And then buyer needs to initial, not check mark. You can check mark up here, but down here, your buyer needs to initial one of these boxes. Either they want to do a 10-day assessment, or they want to do an inspection, a lead-based paint inspection, a 10-day opportunity to do that. And if they initial in that box, it says if this box is initialed, the REPC must include the lead-based paint addendum. That's the only time that the addendum is required. Then, because it's an addendum, it becomes part of the transaction, becomes part of the real estate purchase contract. Okay. But this is not an addendum. This is just a disclosure. So first, the seller discloses whether they have any knowledge or any reports. Then from that information, you are your buyer and you are going to make a decision whether they want to do a lead-based paint inspection or not. If not, then they would initial double I, which says by initialing this box, they have waived the opportunity to conduct a risk assessment or inspection for the presence of lead-based paint. Okay. And then D says buyer has reviewed the information above and certifies to the best of buyer's knowledge that the information is true and accurate. There have already been a couple of these close to home. I think one in Idaho that an agent got caught not delivering the pamphlet. And even though this says that they're signing that they've reviewed and everything, I'm not so certain that a judge might not still side with the buyer. If the buyer says, well, they just put this document in front of me and had me sign it. I didn't know that I was signing, all that information. And so I never received the pamphlet. And so, to make sure I am, like I said, we're making a very strong suggestion that you have in fact, I have an example here. Here's the protect your family from lead in your home. And here's two ways that you can do this, or that I'm recommending. First of all, you can just put received and the date and then have them sign. Okay. Or you can I've been putting this on it because it's an 18-page pamphlet. 18-page pamphlet received on 5/21/25, and then their signature. So I do it. You can see why I'm not saying on the first page because it's already dark blue and so can't see it real well. Or you can put it on the last page, and the last page has a lot of white on it too. But this pamphlet just alerts them and tells them of all the dangers of lead-based paint. And so it's important that you make sure that, especially when you are the listing agent, you make sure that it is getting delivered to the buyer's agent and to the buyer. Okay, and that's the best way to know for sure.
John,
Yeah, go ahead. Question.
what is more common that you see that people just forgo, like doing an inspection for lead-based paint? Out of 10 homes built before 1978, what are most agents doing?
Most agents, for the reasons that I stated a little bit earlier, because let me tell you why lead-based paint came about, because it came about the same time that I got into real estate 35 years ago. The biggest problem they were having, not only with lead in the air and being ingested, but there were babies that people would put their babies' cribs by a window that had a windowsill, and the baby's teething, and so the baby starts chewing on the windowsill. I know all of my kids chewed on our windowsills. Okay.
What?
You would think that we would be smart enough to move the crib, right? But anyway,
Explains so much about Corey.
Wow, that was rude.
that was brutal, wasn't it? Yeah. Okay. So anyway, but babies were getting lead poisoning, and there were some people that were getting it as well. But I've talked in classes that I've taken. Kind of the general consensus is since 1978, how many times has a home been painted on the inside, on the interior? If it
Yeah.
has 3 or 4 layers of paint on it since then it's covering up anything as far as lead-based paint. And so the danger is not as serious. For those there are some people that, are just on edge about anything, radon, lead-based paint, meth, whatever. And so it's not a bad idea to have a lead-based paint inspection if they are concerned. Okay.
Let me give my answer to that.
Yeah, because they didn't really answer my question as to
Yeah,
how.
I'll give you the real answer. So the real answer is no agents are doing anything because it's not the agent's decision.
But
So the
okay,
agent's not doing it. So,
how many
but
buyers?
buyers in general are waiving their right to do
Yeah,
it.
I did answer your question. I
You
said
did. Yeah.
most of them are not doing it.
But here's
Because
the
lots
discussion
of
I have
paint
with my
after on
client,
top of
right?
it.
I have this discussion with them and I say, hey, look, the home was built before 1978. There's a really high chance that there's lead-based paint in the home. And so if you test and you find lead-based paint are you going to back out of the transaction, or what are you going to do? Right. And so I have that conversation and decide what they would do. And if they're like, no, I don't really care if there's lead-based paint, I'm still buying the house, and there's really no reason to go through that extra step. And the other reason that most people are waiving that is because when I talk to my clients, I say, look, you have a due diligence period and you're welcome to test for lead-based paint during that due diligence period as well. It doesn't mean that you can't if you waive this extra protection or whatever, because it falls within the same timeline as the due diligence period.
Absolutely. It's just if you state that you're going to do the lead-based paint inspection on the disclosure, then you have to attach the lead-based paint addendum with the property. Okay. But yes, like Jeff said, you still have due diligence that you can back out for that reason. Okay. So a buyer does have those protections. Okay. So anybody have any other questions about lead-based paint or the lead-based paint pamphlet?
Oh, I have a question, Don, please.
Yes.
Don
Yes.
Sancho here. So, we don't need the addendum on the REPC if the buyer signs the lead disclosure and initials one of the two options at the bottom, right?
If they initial the second box, then you do not need the addendum. If
Okay,
they initial the first box, they're saying they do want to do an inspection, and it says it must include the lead-based paint addendum. Okay.
terrific. Thank you.
Okay. Any other questions, anybody? No? Okay. So remember, just so you know, you can also go to the EPA website, and it has like 27 different languages, this pamphlet. That's how important it is to them. And when you go into the forms, into the legacy forms library, the pamphlet is not in the regular forms that you can type in the filter, but on the right hand side, if you go about halfway down, it'll show the EPA pamphlet or website, and you click on that, it'll take you to the EPA website where you can get the pamphlet. Okay, but we have just to avoid confusion, Jeff has uploaded it into our resource library of forms, our Fathom library of forms. And so we have it in two languages there, the two predominant languages, English and Spanish. Okay. So if there's no other comments about that, let's go on to the next one. Okay. So I just wanted to remind, we're not going to go through the real estate purchase contract. I've highlighted some areas that I want to make sure that everybody understands. Okay. One of the things that I see all the time, when a deal goes sour and an agent has passed all their deadlines to cancel, I get phone calls and they say, Don, help me. We got to find a loophole. There's two places where I go for loopholes. Okay. Number one is I said, well, let's check and see if we're representing the seller. Let's see if the buyer delivered the earnest money on time. Because remember, the buyer has 4 calendar days in which to deliver the earnest money, either to the brokerage, or if you do the addendum, the earnest money to title insurance company addendum, 4 days to deliver it to the title company. Okay. Then the title company has 4 days to put it into their account. But we're just worried about that first 4 days. Now, if you are on the buyer side and you deliver the earnest money late, you are in default. Okay. So how can you solve that problem? It's very simple, because in the beginning of the transaction, everybody's playing nice with one another because everybody thinks, okay, we got a transaction going here. And so all you have to do is an addendum extending the time frame for earnest money delivery. Have both parties sign it, then no problem. Even though it's late, everybody's agreed that that's okay, and so you're no longer in default. You just don't want to say, oh, well, we've delivered it, everything's going fine, I don't need to worry about it. Yeah, you do, because I'll guarantee that there are other brokers that are looking for loopholes for their agents as well. But that's one loophole area. Okay. Let's see. I wanted to just quickly cover, okay, fees, costs, and payment obligations. You should go through this, and it talks about, different fees and rental deposits and everything. I just went through one where where rental deposits, our buyer was looking to close on a property and the renters were going to be in it for 3 more days. And we decided to just extend it because we didn't want to have to hassle with transferring, security deposits and all that, because that's what you have to do if there's a new owner of the property. All those things have to be transferred to that new owner. And then this, of course, covers HOA fees. And one of the things that you really want to look out for is transfer fees. There are some things like out in Daybreak and Harriman. There's some that are, 0.5% of the purchase price of the property. Make sure that your client understands that. Of course, you all know that what we're recommending, there are other ways to do it, and I'm not going to cover those because we believe that this is the best way to ask for your commission, and that is to put it in the offer. So section 4.3E talks about the real estate brokerage compensation commission. And it is the commission that is being paid is called the seller's compensation contribution. I learned that in Jeff's class yesterday because I thought it was the buyer brokerage commission, but no, it's called the seller's compensation contribution. Okay. And so you can ask for a percent, and I highlighted the word or because it's a percent or a dollar amount. And we always try to teach you that anytime there's a blank, put something in it. In this case, do not. Okay. It's one or the other, because if it's or, there actually was a case, I can't remember where it was now, but where somebody put in 3% or 0. They put in 0 and the seller says, well, I choose 0. They gave me a choice and I choose 0. Okay. So don't fill anything in if you're asking for, a percentage. Okay. Don't put anything in that dollar amount. Okay. So that's a little problem area. Okay. Seller's disclosures. You guys, this is a big one. I am not kidding. I'll bet I could go into our files and I'll bet there's 3 out of every 5, maybe 3 out of every 7 that there is some violation there. And as long as the transaction finishes out, no problem. But again, if an agent comes to me and says, Don, help me, we're past all our deadlines, help me find a way we can get out of this contract. If they deliver the earnest money on time, I go to number 7, seller's disclosures. Okay, so first of all, you all know that you have to deliver a written seller property condition disclosure for the property. Okay, you all know that. Okay, you also have to deliver a lead-based paint disclosure and acknowledgement for the property. And then C is the one that we see violations all the time. A commitment for title insurance. A commitment for title insurance. This is not a preliminary PR. Now, what's the difference between a preliminary PR and a commitment for title insurance? A preliminary title report is a title report that you get when you list the property to check to see if there's any liens on the property or any encumbrances that might affect, the sale of the property. Okay. The commitment for title insurance is after it goes under contract. You send copies of your contract to your title company, and they actually send you a commitment with the buyer's name on it, showing how much they're being insured for. So it's a commitment from the seller that they're providing a title policy, insurance policy for that property. That is what needs to be delivered, not a preliminary title report, but a commitment for title insurance. So sometimes if you're given, if you have a buyer that's giving you 3 days to deliver a commitment, you might want to counter back and extend that to 5 or 7 days, because it usually takes a title company, unless you want to get on their bad list and always tell them, oh, I need it by tomorrow, whatever. But a normal turnaround time is probably 2 or 3 days. So you want to make sure that you give yourself enough time to be able to get the commitment for title insurance. Okay. And then of course, a copy of the restrictive covenants. If you just say, oh, there are none, and it turns up that there are some, you put your client in jeopardy. You put them in breach of contract. Okay. Copy of the most recent minutes, budget, and financial statement. And these things are only if they're available and if they exist, okay? And then, of course, copy of any long-term lease agreement, short-term, existing property management agreements, water rights, et cetera, et cetera. But the things that I have highlighted are the most common that you just need to make sure that you look out for. Jeff, you have anything to add?
No.
Okay.
I do have a question,
Yes.
Don.
Yeah.
Hey, what is the best practice in when you pick up a listing, and I see agents adding their sellers disclosures on the listing on MLS or copies of CC&R and stuff. Is it advisable, or are you killing some would be buyers by adding those in? Is it better to not add them in? What is a best
I'm
practice? What are you
I,
gonna
I am
experience?
really glad that you asked that question, Ellen. A really good question. So, is it good to maybe upload those documents? Sure. Right? Seller's disclosures, if you have them, that's nice because then somebody can look over the seller's disclosures before they make an offer. Maybe it's not so good because maybe they're going to look them over and say, "Oh, look, it's got this problem, this problem. We're not going to make an offer on that property." But um, those documents that are uploaded on the MLS do not constitute delivery to the other party. So you still would have to deliver a copy of the seller's disclosures to the buyer, and not depend on, well, I put them on the MLS because being on the MLS does not guarantee that that delivery was made. Okay. So that was something that a question that I asked the legal hotline because that question came up before. So
I would say as far as putting them there, whether it turns a buyer off or not, I don't, I would almost rather that they be turned off and not make the offer than if they're going to be turned off by it. If you deliver them the next day and then they get them, then you went under contract. Now you're back out because they backed out and you're back on the market. I think that looks worse. So I don't know that it's a big deal if you upload them to
yeah,
the.
and I agree with that too. I agree with that too. I mean, it's better, if a buyer's going to cancel, the earlier the better for your seller,
Yeah.
so that they can move forward with, and that can sometimes be a good thing for you too, because you let them know, hey, we've got this problem. Maybe we need to fix that problem, and then we can do an addendum to the seller's disclosures showing that that was remediated or fixed or whatever. And so that's no longer a concern for a potential buyer. So there is some good that can come about because of that as well. Okay. All right. Next sections, you all know due diligence condition. Okay. Appraisal condition. I did want to highlight this because this is something that I don't see a lot of agents doing. They just cancel because of financing and appraisal. But appraisal condition, listen to what I'm going to read you. Buyer may cancel the REPC by providing written notice to seller with a copy of the notice of appraised value no later than the financing and appraisal deadline referenced in section 24C. So if somebody wanted to get really stinky about it and you did not deliver a copy of the notice of appraised value from your appraisal, then they could say, hey, you never delivered that. So, and now you're past your financing and appraisal deadline. So now you can't cancel for that reason. Okay. So make sure that if you're canceling because of appraisal, make sure that you provide a copy of the notice of appraised value. What I normally do is there is one, it's usually one of the first pages that it shows the appraised value. Okay. I don't always get a notice of appraised value on there other than the appraisal is a notice of appraised value. Okay. But there is one page where it's kind of a summary page. So I guess that would be what they're talking about. But just make sure that you follow this practice as well to make sure that you don't put your client in jeopardy. Any other thoughts on that, Jeff?
No, I think you're good there. Again, it's just what you can only use it or need to use it if it's a low appraisal.
Yep. Yep. Okay. So, um,
But can't you back out for any reason, even if it appraises, you can still just back out anyway. So
On financing, not on appraisal.
yeah, on financing, not appraisal, Leah.
Okay, but it says financing and appraisal deadline.
Yeah,
So
they're
you can,
combined as far as the deadline.
So there's two deadlines there. There is an appraisal deadline. There is a financing deadline, but they're the same because you're putting them in the same finance and appraisal deadline. But there's two separate conditions there.
but you don't have to give a reason though. You can just say you're canceling.
If you're canceling for financing, remember the buyer's cancellation, notice of cancellation has two different check marks. You can check mark for appraisal or you can check mark for finance.
So just always check financing
As
if you
long as
don't
you've
want to
got your
be bothered
financing condition
uploading
you can
the,
use. Yeah.
Yeah,
yeah,
because
I'm gonna have to.
if you check mark appraisal and then you didn't provide a copy of the appraised value and you go past the financing and appraisal deadline, the agent could come back and say, sorry, we get your earnest money because you didn't cancel in
Yeah, so
time.
it's safer just to be in the habit of just always ticking financing.
Maybe what if you're a cash offer and you do have appraisal, but you don't have financing?
Say that again.
What if you're a cash offer and you do have an appraisal
Oh,
condition, but you don't have a
You wouldn't have
financing condition?
financing, but you would have an appraisal
oh,
condition.
So you can't always just rely on doing that. It depends on what you have available to you to use.
So
oh.
make sure you know how to use this correctly. Okay, that's what we're
All
trying
right,
to
good
teach.
point. You can't, so you can't cancel because of financing if you didn't even need financing.
Right. Okay. All right.
The people that pay cash, what, they're just ticking, they're putting a deadline there because of the appraisal.
If they're doing an
Yep.
appraisal, or yeah, even yeah.
Okay.
Yeah,
Okay.
I just had that conversation with one of my agents over it's a cash offer and they want to do an appraisal. Can they even do that because it's cash? They don't need to have an appraisal. The lender's not requiring it. Why would they do it? Well, they may just want to make sure that they're not overpaying for the property. They want an appraiser to go look at it. So they can certainly do that if they want. It's up to them.
Yeah. Okay. All right. The next area. We have people all the time that ask about when to do a walkthrough inspection. In the contract in section 11, it says no earlier than 7 calendar days prior to settlement, you can do a walkthrough inspection. Most people don't want to do it prior to anyway, unless it's if it's a vacant property, then you could do it 7 days prior because it's probably not going to change. But I always do my walkthroughs as close to settlement as possible so that I get an accurate picture of the condition of the property just before we close. Also, if there's people living in it and they're, working to get out of the property, remember, because I did have somebody concerned about this, you still do a walkthrough. You can still do a walkthrough and see what the condition is, but okay, they've got boxes all over. What about if they damage the place? We've already done our inspection. Remember, that is covered. That is covered in this contract because it's something that survives closing. Okay, so you're covered either way. Okay, changes during a transaction. I just thought I would highlight this and let you know. Once a property goes under contract, the seller can do no substantial alterations or improvements, no further financial encumbrances, and no changes to any existing property management agreements on the property once it goes under contract without the permission of the buyer. Okay, they could get permission from the buyer and then they could do that if both parties are okay with it. But that's something that you probably should know. No changes to any tenant lease or rental agreements. You may not, after the seller disclosure deadline, continue to accept short-term rental bookings. Okay, so if you have, if you're using your property for Airbnb, the seller may not, after the seller disclosure deadline, continue to accept short-term rental bookings. Okay, so that's where the cutoff is for that. Okay, authority of signers. You guys, we get this all the time. Authority of signers: if a buyer or seller is a corporation, partnership, trust, estate, limited liability company, or other entity, it's the person signing the REPC on its behalf warrants his or her authority to do so and to bind buyer and seller. So if they are, if they are the trustee over a trust or something, we generally want you to get a copy of what shows that they are legally that they are legal to sign documents for that LLC or corporation or trust. So are we having them upload those into IntelliAgent, Jeff?
Yeah, Beverly usually requires those.
Yeah. So just remember that um, even though this says that they're stating that they do have the authority to sign on behalf of their entity, we're still requiring a copy of something that shows that they have that authority. Okay, so just get that ahead of time, and then you won't have any problems. Okay. Um, Go down to mediation. Mediation. I get a lot of may at the option of the parties. The only time I check mark may at the option of the parties is if my client insists on that. Because the way I explain this to them, there's two ways I explain it to them. Number one, shall means that we'll go through a mediation process before jumping into court. Number one, that's a good idea because I think that mediation is kind of a cooling off period. Everybody has a chance to kind of rethink through things, and then the mediator tries to bring the two parties together and help them to meet halfway. Every mediation I've ever gone to or been a part of, I find that you've got the sellers, the seller story on this side of the spectrum, the buyer story on this side, and the truth is always somewhere in the middle. So the other reason, and I'm serious, more times than not, when we've gone even into small claims court, the first thing a judge will ask is, have you tried to mediate this? And if the answer is no, Your Honor, we have not gone through mediation yet. And then he says, well, get out of my courtroom and go through mediation first. If that doesn't work, then you can come back. In fact, one of the times the judge sent us, the buyer and the seller and their parties, out into the foyer to go out and see if you can come up with an agreement on your own. And if you can't, then you can come back in. So those are two good reasons, I think, to to advise your client that it's a good thing to check mark shall. Jeff, do you have other thoughts on that?
No, like you said, it's up to the client, and so I explain it, and then they have to decide. But I
Exactly.
prefer shall. If they ask which one I prefer, I always prefer shall.
Perfect. Okay. Then you guys, some of you probably don't even know. We talk about default a lot. If you don't deliver the earnest money in time, you're in default. If you don't, deliver everything in Section 7, seller's disclosures and things, you can be in default. What happens if a buyer or seller is in default? Well, the remedy is the same for either party. So, first of all, I have agents all the time that, oh, well, then you get the earnest money. Well, that's not an automatic because you have choices here. So, here's what the choices are. If the buyer defaults, they can cancel the REPC. It says the seller may elect one of the following remedies. They may cancel a REPC and retain the earnest money deposit or deposits as liquidated damages, or they can maintain the earnest money deposit or deposits in trust and sue the buyer to specifically enforce the contract, or they can return their earnest money deposit to the buyer and pursue any other remedies available at law. So they do have choices. The most common choice is just to accept the earnest money, right? So if the buyer defaults, the most common remedy is the seller will say, well, then I get their $5,000 earnest money. And that would be correct. Okay. Seller default is basically the same thing. It says buyer may elect to accept from seller as liquidated damages a sum equal to the earnest money deposit, or maintain the earnest money in trust and sue seller to specifically enforce the REPC. We have one right now that just went through this. The seller wanted to back out, the buyer wanted the property, and so he says, hey, I'm going to take you to court and sue you to show me the property if you don't. So the seller changed their tune, and the reason the seller didn't want to sell it all of a sudden is they had somebody in the wings that was going to offer them more money. So they wanted to be able to cancel this offer and accept another one. Or they can accept a return of the earnest money, deposit, and pursue any other remedies available at law. If
I
buyer,
have a question.
wait, hang on a second, Leah. If buyer elects to accept liquidated damages, seller agrees to pay the liquidated damages to buyer upon demand. Go ahead, Leah, with your question.
With the seller disclosures, you've got to get it to the buyer within 4 days, but when does the buyer have to, do they have a deadline on when they have to sign and get it back to you?
The seller disclosures is not a 4-day timeline. Remember the seller
Oh,
disclosure, there's a deadline, whatever date you fill in section 24 of the REPC is the deadline for the seller's disclosures. You're thinking of earnest money. Earnest money,
no. I'm thinking of the seller I'm asking, is there a deadline as to when the buyer has to sign it and return it?
there is no deadline. Okay.
Okay, it's only
But
on the seller.
we
It's
don't
only on the
generally,
listing agent getting it over to them,
yeah, we
but
don't
there's no
generally have
deadline
a
on them
problem.
getting it back.
We don't generally have a problem with that. But let me tell you why we generally don't have a problem with that. And everybody listen to what I'm going to tell you. When your buyer initials each page and signs the last page, they are not agreeing to everything that's in the seller's disclosures. All they're doing is showing that they received a copy, and it actually states that on the last page. I think it's the last page of the seller's disclosures. All they're doing is confirming that they received a copy. So the best practice would be when you get the seller's disclosures from your seller, get your buyer to sign it right away and initial all the pages and get it back to the other agent as quickly as possible. Okay. That would be the best practice. Okay.
We don't usually have a problem because buyer's agents need a full file in order to get paid, and so they usually get it back to us.
There you go.
Oh,
Okay.
I just that the person on the buy side hasn't got it back to me, and I feel like it's been 6 days. So I sent an email today asking them for it, and I was just
Perfect.
wondering if there was a deadline, but there's
Nope.
not. Okay.
Yeah. All right. And default here and mediation, section 17 is a gentle reminder that the reason why you want to do mediation, you guys, because if you jump into litigation, okay, and litigation, when you go into court, a judge can make a decision on awarding monies or whatever. And he also, what if the other side hires an attorney and there's attorney's fees? Section 17 just nicely states that in the event of litigation or binding arbitration arising out of the transaction contemplated by the REPC, the prevailing party shall be entitled to costs and reasonable attorney's fees. So whoever loses is going to pay the other side's reasonable costs and attorney's fees as well. However, attorney fees shall not be awarded for participation in mediation under Section 15. Okay? So this contract shall be governed and construed in accordance with the laws of the state of Utah. So you want to make sure that's why mediation is a good idea too. Because if you don't have a real strong case and you lose, you're going to pay the filing fee for if it's small claims court, and you're going to pay any legal fees that the other party has. If they brought an attorney, then you're going to end up paying their attorney's fees. Okay. No assignment. There's been a misnomer out there that people think that if you put on a contract, that the buyer is Don Zimmerman and or assigns, that means that I can assign this contract to anybody I want. It does not. Okay. If I put Don Zimmerman and or assigns, it simply means, in fact, it simply means that I can do a permissible transfer. A permissible transfer is I can transfer it to an entity that I have ownership with. Okay. So it says, the REPC may not be assigned by buyer without the prior written consent of the seller. So you have to get a written consent if you're going to assign it to anybody else. Provided, however, the transfer of buyer's interest in the REPC to any business entity in which the buyer holds a legal interest, including but not limited to a family partnership, family trust, limited liability company, partnership, or corporation, collectively referred to as a permissible transfer, shall not be treated as an assignment by buyer that requires seller's prior written consent. So you can do a permissible transfer without the seller's written consent, but if you're going to transfer it to anybody else that you are not affiliated with, then you have to have something separately signed by the seller. Okay? All right. Then just a reminder, you guys, because we always see problems with this. Time is of the essence. you guys pay attention to the deadlines. And this also is where it states that if you don't state something differently when somebody for the time frame for someone to respond, uh, then it says performance under each section of the REPC which references a date shall absolutely be required by 5 p.m. Mountain Time on the stated date, unless it is stated otherwise. Okay. And the term days and calendar days shall mean calendar days and shall be counted beginning on the day following the event which triggers the timing requirement. So if you sign something on a Friday, day one would be on Saturday. Friday to Saturday is day one. Okay. So just remember time is of the essence. Okay. Then you guys, this is something that I hope you all know. I hope. This should always be addendum number 1. Why should this always be addendum number 1? Because it needs to be sent with the real estate purchase contract that you're submitting. The REPC and this addendum are the minimum that you need to send when you send an offer. Okay? Why is that? Because we are asking for something different than what the REPC states. We're asking for our earnest money to be deposited with a title company instead of at the brokerage, which is what the very first paragraph says. Agrees to deliver no later than 4 calendar days after acceptance an earnest money deposit in the amount of blank. After acceptance of the REPC by buyer and seller and receipt of the earnest money by the brokerage shall have 4 calendar days in which to deposit earnest money into the brokerage real estate trust account. Since the REPC states that we'll deliver it into the real estate trust account, we do have a trust account. Just so you know, by law, we have to have a real estate trust account, but we have chosen, Fathom has chosen to deposit our earnest monies with the title company. So that's why we have to do this addendum and why it has to be submitted as part of the offer. It is part of the offer. Okay? All right. I brought this form up because I'd had a couple of questions on this. Do you have to use this form for confirmation of receipt of earnest money when you deliver the earnest money? No, you don't. If most title companies have a receipt of earnest money, but the important things that we need to see is we need to see, first of all, it should be on letterhead so we know who it was delivered to. We need to see the address of the property that it's on, the amount of the earnest money, who received it, and the date that they received it. Okay, the reason I brought this form up is as we all know that when we represent a buyer, that we have 4 days to get the earnest money to the title company, okay? So, and as a courtesy, you should always send that receipt to the listing agent so that they know that you delivered it on time, okay? If you are the listing agent and, you know, the 4 days has passed and you haven't heard anything from the buyer's agent, I always contact the buyer's agent and ask them, can you please send me a copy of the earnest money deposit or the proof that the earnest money was delivered within the 4 calendar days? That way I'm protecting my seller because again, you know, we want to find out if they haven't delivered the earnest money. Earnest money delivery is the first promise that a buyer makes to a seller. Okay, that's the first deadline that they have committed to their seller. So we want to make sure that that is accomplished because if it isn't and they don't have the earnest money or whatever, how, you know, that should raise some red flags. And so you will have a discussion with your seller. You know, if they're in default and they didn't deliver the earnest money, you can cancel the contract due to default on the buyer's behalf, and you actually could go after the amount of the earnest money. But most of the time, you just want to know if they're not serious about this, then let's cancel the contract. But you want to protect your seller in any case to make sure that that earnest money has been delivered. And this is a form that you can send to the other agent if they you know, say, well, we don't have a receipt. Well, here, I'll send you the form from the MLS, and please have whoever received it fill that out. Okay, any questions on that, you guys?
I
Yeah,
don't,
I have a
Don.
question.
Oh, sorry. But I have a question of something else. I'm just concerned about the time, please. But someone has a question on this.
Yeah, go ahead.
How's it going, Don?
Good. How are you?
Good, good. Hey, so just as far as summaries go, do you guys have a cheat sheet for processes, best practices, just going through buyer process, listing agent process, kind of a cheat sheet for each, step one, step two, step three? That would be very, very helpful summarizing all this stuff because there's a lot of details and there's been some changes since, I got my license, obviously, right? There's been quite a few changes. Just like you said, submitting addendum 1 with a REPC, that kind of thing. That would be really good to have on like a cheat sheet. I don't know if it's like 1 through 15, systems and processes. That way you've got a checklist and you're not missing anything.
Yeah. Probably one of the reasons why we've never done a cheat sheet like that is there are some things that definitely are, could be put on a cheat sheet so that, for instance, the earnest money to title company addendum should always accompany the REPC. But sometimes in the process, different agents do things differently than maybe what we would dictate, things that aren't quite as pressing as that being addendum 1. But I don't know. What do you think, Jeff? Would it be worth it to come up with there kind of is in
I mean, you've got a forms checklist in IntelliAgent. That's probably what you were going to mention. So the forms checklist is there as far as what you should be using for both buyer and seller. So that's there, hasn't really changed.
But there's not timelines on those, right?
Timelines.
Is there a date attached to each checklist?
Well, there's timelines written into the contract right here. It says it's 4 calendar
Yeah,
days.
but that gets convoluted, right? When you're having to search through 4 pages to find a deadline, things can get missed, and they do get missed. So what would be very helpful is to have a list of like, hey, 1 through 12 or 1 through 15 with a deadline for each thing. Okay, this needs to be done in 4 days. Okay, this needs to be done, when you submit your REPC. And it could be even like, 1 page. Yeah, I think that'd be very beneficial.
I understand.
Yeah.
This is Ellen. Can I exactly know what he's saying. On the buyer's checklist on the left-hand side, the top, I have this all the time, and it's on the offer contract, and that says basic offer form set, and it says the REPC, and then the second is deposit of earnest money, and then so it has all those stuff that we are supposed to have. So this is really helpful, this buyer checklist. I give this to my clients, but it's also a roadmap for me as well.
Yeah, there is a buyer's checklist and there's a listing checklist that are already in the Fathom forms. But I understand what you're saying, Jeremy. Jeff and I and Bill, the principal broker, we'll talk about that and see if that's something that we think would be, would be beneficial or.
Yeah, and Don, even if somebody decides to go outside of those parameters or customize it a little bit, at least they understand this comes first, this comes second, this is very important, don't miss this deadline. Those are things that if you could just look at a cheat sheet. I mean, look, pilots have a checklist for a reason. It's so that they don't miss systems and processes when they're starting up their plane and crash. And honestly, especially with all the changes that have come down the pipes, the last year, it would be pretty beneficial to have those things so nobody's just, oh, I forgot about that one. Oops, I forgot about that one. See what I'm saying? And we could even update it from time to time. You know what I mean?
I know what you're saying. I'm just, sometimes if you put something down that not everybody understands the same way, it can be interpreted differently, and then then you're liable for well, you didn't explain that well enough or whatever. I don't know. There are some reasons why not to do that and why agents need to learn it on their own. This is your business. You are an independent contractor, but we'll talk about it, Jeremy, and see if that's something that we think would be beneficial and that we could do in a way that everybody would understand. I mean, I don't think it's a bad idea. I think it's a good idea. I just I understand why we have never done that. I know I brought that up before. It's been and with my previous company, and everybody's always gun shy to put something in writing, afraid that well, Don, this is step 4. And I did that exactly how you did. And, this happened. And so it's your fault that happened because you dictated that as step 4.
Well,
So,
I mean, as long as it's part of the rule book, there shouldn't be a liability problem.
yeah, well, I don't know. That's been a reason that I've been given by, like I say, my former company. But
Yeah.
I have
I
to
mean, if I'm a
do that.
broker, this would probably be beneficial for helping my people not get in trouble. It'd be the opposite. I would be avoiding liability. Hey, here's your checklist, right?
Don,
Well, at some
sorry.
point, I and Jeremy, I agree with you, but I don't. Because at some point, the agent has to become responsible for learning these things themselves rather than us spoon feeding it to you. So,
Don, I don't think it's a question of spoon feeding. And I also don't think it's a question of the agent being responsible or not responsible. When you're going through training, you're learning these things for a reason, and so that you can execute those things.
and we do have
Creating a checklist
training
would
for
be
brand new agents.
beneficial.
We do go
Sure.
through some of these things for brand new agents. So, yeah. So, like I say, Jeremy, we'll take it under advisement. We'll talk about it and see if there's something we can do. Okay. Appreciate you bringing that up. Hey,
Don, sorry to be here so like insisting, but I'm just conscious about the time. So because today we talk about forms, and I'm happy to take this offline if you feel more appropriate. So can we please talk about what forms to use when we as the listing agent have a buyer unrepresented that send us an offer over email, and they do not have the ability to use forms, and they do not want to be represented. Like they do not want the dual agency, but they want to send an offer, but we cannot use the offer, or I don't know, as far as I know, we cannot use the offer as an email with so many freaking conditions.
This is a good question because an unrepresented buyer, okay, and this is straight from the Division of Real Estate, okay? The Division of Real Estate says that you cannot help them, an unrepresented person, with the offer. You can't advise them. Otherwise, it could be implied agency. So all you can do is go to the buyer's checklist and print out a copy of all the forms that you generally would use if you were representing them. And you can hand them a packet of blank forms and say, these are the forms that the Division of Real Estate requests that you fill out, or that we request that you fill out. And then the reason why now in the listing agreement that there's a place for an unrepresented buyer commission is because you have to do extra work, and this you can explain to your client. Because if you have an unrepresented buyer and I give them a packet of blank documents and they fill them out to the best of their ability, if there's things that are incorrect in that, how do you correct them? You're going to have to do an addendum, aren't you? An addendum, you may have 27 things on that addendum that you have had to correct because they chose to be unrepresented and kind of muddle through filling out the documents. And so that's the reason. That's probably the biggest reason why they added that unrepresented buyer additional commission on the listing agreement. So yes, you can give them a packet of blank documents, but you cannot advise them. You can't help them fill them out. You can't do any of that. Yeah, the only thing you can do is once you get the offer back from them, then you can do an addendum to correct anything that they've made the mistakes on. Okay, Jeff, you have anything to add to that? You're on mute, Jeff.
No, not really. I mean, state of Utah allows buyers and sellers to create their own contracts or with attorneys, and so they don't necessarily have to use UAR's forms. They can use whatever they want. If they sent you a purchase contract that just simply said, we'll buy your house for $100,000, that's a contract that's signed by them. Now, you probably, if you're on the listing side, want to go back and do a whole bunch of, probably want to counter them with the actual REPC so that your seller's protected in a lot of ways. But it counts.
Yeah,
but we don't have the ability to help them. They can do whatever they want. If they're truly unrepresented, we have to let them be truly unrepresented.
Yeah, but
Can you send them a video? There's a video online that shows
no,
them how
no,
to.
Leah.
No, not from yourself. Not from yourself. It's
No,
like
you're
an
advising them
agent
to
that's
use,
showing you
you're
how to fill it
advising them
out.
to use the data in the information in the video that you're sending them. It's
That's
their job
in
to
the video.
figure it out.
Yeah, that's advising them, Leah. Okay. All right. So I agree with Jeff that, yeah, they can go to an attorney, but if they don't want to be represented, they're probably not going to go to an attorney to have forms filled out. So you can hand them the forms and tell them that these are forms that we use, and they're the common forms that we use, and they may be forms that Fathom requires, or that, you know, uh, uh, however you want to say it. These are forms that are used in a normal transaction. So these are the ones that I would recommend that you fill out. However,
Question. So Jeff said that we can counter with the actual REPC. Like, let's say that I received this email with terms of an offer, and the seller could actually counter with a REPC, because the REPC would say like a buyer and then seller as the acceptance.
Yeah, so your counter would have to be basically a copy and paste because you couldn't use the actual REPC itself since the REPC is a purchase contract, right?
Mhm.
You're making an addendum to whatever they're using for a purchase contract. But you could copy and paste certain sections or all sections into your own addendum, countering whatever they're sending you. So it might be a ton of work depending on what they send you as far as an offer.
Gotcha.
What
I
I would
still don't
recommend,
get
what I
this.
would recommend, or what I would do is I would send them a blank REPC and tell them, hey, your terms, everything look great. You need to put them onto a purchase agreement.
Yeah, you can certainly
Okay.
say my seller is instructing me that they do not want to see an offer in this form. They would prefer to see an offer in this fashion. And here's, a contract that they would prefer to see it in.
And why is that? Let me explain why that is. An email is not signed by the buyer or the seller. An email is just something that is maybe you're brainstorming. This is what I was thinking for an offer. It does not become a binding offer until you put it on a document that both the buyer and seller sign and agree to. Does that
Sure.
make sense?
Yes, thank you so much. I'm so sorry. I gotta go.
No, you're fine.
Okay, thank you guys.
we're
You're the
over time.
best. Bye-bye.
We're over time. Any other questions, you guys?
Well, Don, I still want to understand more about that because I had an agent where
There's nothing to understand, Leah. Let me explain again. If you're sending them a video and saying, here, watch this, this is what, then you're advising them. You're giving them something, a help. You're helping them. Okay.
But what happens? Because I've had an agent, but just before we had it, the buyer had to sign that filled out the REPC for the unrepresented buyer. He just had the seller sign it first, and then he had the buyer sign it that I had been showing homes to. And he said, well, he didn't tell him how to fill it out, but he filled it all out for them and just got them to sign it.
Just because another agent does something wrong, Leah, doesn't mean that you should do it wrong. Okay.
But like
that other agent could lose their license because they do not have a representation agreement with that party. And if they're helping them in filling out the contract on their behalf, that's implied agency. Okay. And what do we have to do before we ever write an offer for somebody? We have to establish agency. We have to, even if they're unrepresented, we have to establish that I am representing the seller. Okay, you don't want to be represented. Okay, so you have to sign this unrepresented buyer agreement. Okay, well, I'm not going to sign that. Well, then I'm sorry, I can't work with you unless we have established agency first. The Division of Real Estate wants to know who is representing who in every transaction that happens. Okay, and so you have to
makes me wonder how like it all just got passed from their side. Like if he filled it out, had the seller sign off, and then the buyer sign, and they're I've looked it up and it says they were unrepresented. He didn't represent both sides, but I mean, he got away with it. So it's tempting to
So
think
do
you
it.
could
Yeah.
do
I
the
mean,
same.
if anybody can get away with stuff, you might as well just go ahead and do it. I
Yeah,
mean,
follow
what's the
everybody
worst that
that's
can
getting away
happen?
with stuff, Leah, and see how your career
Holy
goes.
smokes.
Okay.
Well,
Leah, he would be what I call a great example of what not to do. Okay. That would
but
be
what's the risk for him when he got like the
risk
salad
is, guess
puppy?
what? Now that you know it, I'm gonna hammer you, and I'm gonna find out who it is, and I'm gonna turn him in. I'm gonna turn him into the division. Let the division handle it. Okay.
No, I don't want to
Why?
take
Why?
me.
Now, Leah, you laugh about that, but let me explain this. Okay.
It is annoying to me though,
We
but like
are
it's not
in,
his fault.
hang
Like,
on, let me explain. We are in a self-policing industry. If we have people that are breaking the rules and tempting us to break the rules too, I'm going to turn them in every single time. Okay?
I just figure
I
the
I
buyers.
don't want to be looked at as a used car salesman. I want people to know that I have the greatest integrity and I'm going to do things correctly and follow the rules. That's the way that you should do real estate, okay? So
Yeah.
don't follow the naysayers, okay? You follow Jeff and I, okay?
Okay.
Okay. Sometimes, you just have to. I've turned agents in for doing things like that, Leah. Do you know what
I didn't see it as his fault. It's their fault because they got me to show a bunch of homes. Then they found out that they knew the seller, and they're the ones who said to the listing agent, "Hey, we just don't want to be represented."
it
So it's their
doesn't
fault, not
matter.
his.
It
But
doesn't
he
matter whose
still,
fault. It doesn't matter whose fault it
It's
is.
his fault. He
yeah, because
didn't
he
do what he
still
was
didn't
supposed to do.
say, no, you need to have
Yeah,
representation or
it's
I need to
still
do
his
limited
fault.
agency.
And
He
it
still
is his
filled it
fault.
all out for them so they didn't have to be,
That's
they
his
think
fault.
they were getting a better deal.
He
You
did
just
something he should not have done.
you
But
He
I
just
mean,
should
I
not have
described
discussed
filled
it. I
that out.
called him because I had messaged him about the house before they went and on their behalf. And
So are
yeah,
we
it's still
continuing to
bothering
talk
me.
about why he's continuing to do something he shouldn't do? Is that what we're trying to do?
I'm just trying to work because I guess I've wanted to do the same and
You
write up
can't.
the REPC, and then I'm being
Nope,
told that you can't. But
you
I know
can't.
a very successful agent, they're not in our brokerage, that
Doesn't
has done
matter.
it. So it's like, well, people can do it. And I asked him, how do
Sure.
you
Leah.
do
If
Here's
that?
the
you look in
simple
the
answer.
newsletter, if you look in the division newsletter every quarter, there are people who try all kinds of things and they get caught and fined.
And here's the
Some
simple
get
answer, Leah.
caught, some don't.
The simple answer is here at Fathom, we do not allow you to follow people that are doing things incorrectly. If you
It,
do that and we catch you, I'll guarantee you will no longer be an agent at Fathom. Okay. And that's just
Wow.
because
Maybe I think he's
hey,
actually
let
a
me
broker,
finish.
so
Let me
that's how
finish.
he got away
You
with it.
let me
Okay.
finish it because you then have not, you're no longer an asset, but you have become a liability. Okay. And there's no company that wants to have a bunch of liabilities if they know about them. Okay. And I'll guarantee that that agent, if their principal broker knew that he was doing those things, I'll guarantee that he would probably have the same
What
conversation.
happens if he is actually a broker himself?
and he gets caught.
Oh, okay.
Leah,
If the
Makes
division
me
finds
wonder if
out
I
that you
look
did
him up
something
and I
wrong,
see that a lot on his transactions that he's the listing agent and then there's no buyer's agent, it will just make me think, okay, it's happened besides on the one deal I know of. This is interesting.
I
But look,
wonder if
I
he's
don't want to get
hiring
him in
Leah. Maybe,
trouble, but
maybe
Leah,
if he's
just
a
think of
broker
it
and
this
he's hiring,
way.
you can ask.
You
What was
can
that?
rob, or say, think of it this way, Leah. You can rob a bank and you could get away with it, but in the end, it's still not legal, and more than likely people will turn you in because robbing a bank is wrong.
yeah,
So
because I don't know, he might have
you
got both
can use
listing sides. He
so
might,
with
because
this side, you can turn him in and have him investigated if you think it's wrong.
look at
Because what
Jeff.
he's doing is
Yeah,
illegal. Other than that, not your business, not your problem. Don't worry about it.
Cheryl, thank you,
yeah,
because what she just said is the opposite of what you're saying. You're saying, well, I see he's getting away
got
with it,
one.
so it makes me want to do that too. No, instead of that, you should be saying, hey, that's not allowed in our career field. I'm going to correct that by turning him in. Go to the other side of that. Don't go to the dark side, Leah. Follow the light. Follow the light. Okay.
Okay. Okay, this little light of mine, I'm
Yeah,
gonna
to
shine.
James's
Okay.
point, why are we still discussing this? We're
Okay.
pretty much at time.
Yeah, we are. We're done. You guys, thank you so much for hanging in there with us. Does anybody else have any other questions besides Leah? Okay. Anybody else? Any questions? If not, thank you so much for being here, you guys. I really do appreciate it. Leah, we do appreciate your questions. And Jeremy, we don't mean to be hard on you guys, but you know, we'll get through this together, okay? So,
Thank you.
all right. Thank you.
Thank you,
Bye.
guys.
Have a wonderful rest of your week and a wonderful holiday weekend coming up. A 3 day
Woohoo!
weekend. Woo.
That's right.
You can do
You
more
guys
real
have a good
estate,
one.
right? You can do more real estate. Okay. All right. Thanks, you
Ciao.
guys.
Bye.
Bye bye.